Okay. This is going to be interesting.
Good afternoon, ladies and gentlemen. A well-regulated militia, comma, being necessary to the security of a free state, comma, the right of the people to keep and bear arms, comma, maybe, right, shall not be infringed. So when I was in law school, the idea that at a conference of progressive lawyers, those words might be the subject of a heated debate would have been startling. I was in law school around the same time that Chief Justice Warren Burger, who we'll recall was a relatively conservative judge, said that the idea that the Second Amendment protected an individual right to own handguns was a fraud. In fact, he called it the greatest fraud, one of the greatest frauds that had been perpetrated by special interest groups that he'd ever seen. And here we are now, about 25 years later, to maybe investigate that fraud or maybe to say that the chief was wrong. So I can imagine a better, more learned, more provocative panel to help us to think about this issue, and especially the recent Supreme Court case, the District of Columbia versus Heller, U.S. versus Heller, which involves the Supreme Court reviewing the gun control laws of the District of Columbia. And I just want to mention briefly two encounters that I've had with those laws and then introduce our wonderful panel and get this conversation started. So the first point of entry I had was as a prosecutor here in the District of Columbia. I actually have put some people in prison for violating the handgun laws. When we learned about this law in prosecutor training school, a little training session that they put on for us rookie prosecutors, the subtext was that basically it's illegal for anybody to have a gun in the District of Columbia, and anybody who has a gun will be dealt with by us. The Second Amendment never came up. Now, as a formal matter, you can own a gun in D.C., not a handgun, but a firearm, but there's a lot of hoops that you have to go through specifically designed to prevent you from using it to protect yourself. And again, the subtext in training at the U.S. Attorney's Office was that if anybody had a gun in D.C., we're going to put them in prison. Second Amendment never came up. Left the prosecutor's office, started teaching. I teach criminal justice stuff and also race relations. And when they asked me to do this panel, unlike the other people on it, I haven't written about this issue. I knew it related a little to criminal law, but I was actually looking forward to taking a break from the race relations stuff to think about this issue of the Second Amendment. And then when I started reading about it, it turned out I couldn't do that. Militia, you heard when I mentioned the Second Amendment, but that's not the first time that it comes up in the Constitution. Article 1, Section 8 states that Congress has the power to call forth militias to, among other things, suppress insurrections. So when you think about the Second Amendment, among other things, you have to think, well, what's the big deal about militias? And the big deal, one of the biggest deals was slavery. In the South, the purpose of militias was to suppress slaves from rising up against their masters. This was a huge concern. The worry was that the federal government wouldn't have the political will to prevent slave insurrections, and so the white males who were members of militias, white males being members of militias, one of the phrases that occurs in one of the briefs in the Heller litigation. But the concern then was that the white males who were members of militias would need to have their arms to do that work. And in fact, that happened in South Carolina and other places, that militias were used to thwart slave rebellions. It's one of the reasons why Southern militias, most of them didn't participate on the side of the revolutionaries in the American War because they had to stay at home and control the slaves. So I didn't get to take my vacation from race that I was hoping, but I'm really looking forward to a great conversation about how all of these issues implicate us now in the District of Columbia and perhaps in the United States. And to have that conversation, we have a wonderful panel. I'll introduce them, beginning with my far left, Dennis Hennigan. He's the Vice President for...
You're close left.
I'm sorry. Closest to me, not my far left, my nearest left. Dennis Hennigan is the Vice President for Law and Policy at the Brady Center, the Brady Center to Prevent Gun Violence. He's the director of its Legal Action Project. He's co-authored a book called Guns and the Constitution, The Myth of Second Amendment Protection for Firearms in America. And he also leads a team of lawyers at the Brady Center that, on a pro bono basis, represents people who've been the victim of firearm violence. He sues the manufacturers and the sellers of the guns. Next, we have Adam Winkler, who's a specialist in American constitutional law. He teaches law at UCLA Law School. He's one of the co-editors of the Encyclopedia of the American Constitution, and he writes about a number of issues in addition to constitutional law. He writes about social corporate responsibility and international economic sanctions. To the left of Adam, we have Mark Tushnet. Professor Tushnet is the William Nelson Cromwell Professor of Law at Harvard Law School. He's the author of 4 case books, including the most widely used constitutional law case book. Most relevant to this panel, he's written a very well-received book about the Second Amendment called Out of Range, Why the Constitution Can't End the Battle Over Guns. And last but not least, we have David Gossett, who's a partner at the Washington, D.C. office of Mayer Brown, LLD. His practice focuses on the Supreme Court and appellate litigation. He's been named by Washingtonian Magazine as one of the top 40 lawyers under 40. He's already argued 2 cases before the Supreme Court, and he's the executive editor of the Green Bag. So we're going to get started now with the conversation. We wanted to make this panel less talking heads and more just a discussion about these important issues. So we're going to get some views and some background from the panelists, and then we're going to open it up to you all and have a conversation with you as well. Okay. So what's this case about? If we could have a quick overview of the issues, and let me just, from David, if you could, again, especially focus on the Heller case.
Sure, happy to. I think, though, it's important to start such a discussion with a little bit of history. As Paul said 25 years ago, the argument that the Second Amendment would be precluding a locality from regulating handguns would have been viewed as a fraud. This all changed, to my mind, just over 20 years ago, or just under, in 1989, when Sandy Levinson wrote an article in the Yale Law Journal called "The Embarrassing Second Amendment," in which he questioned the then very well-established view that the Second Amendment was about preventing state militias from being regulated by the federal government. And this article, I hadn't known this until 5 minutes ago, and Dennis tells me this article actually made the New York Times. It's very rare that law review articles get covered by mainstream journalism, but this article made it into the New York Times. It didn't have much other effect for quite some time, though, until 2001, when the Fifth Circuit in the Emerson case issued this 85-page opinion taking the view that the Second Amendment would protect an individual's right to own and use handguns for personal defense, for hunting, for such things. this was largely out of nowhere at that time. And in fact, one of the three judges on the panel issued a concurring opinion arguing that the entire opinion of the majority panel was dictum because the case had to do with the possession of machine guns and other fairly extreme armaments. And the panel, in fact, all three judges on the panel agreed that whatever the Second Amendment meant, the government could bar the private possession of machine guns. The Emerson case, though, had a receptive audience of one person who mattered quite a lot, and that being our dear friend John Ashcroft, who at that time was the Attorney General, and took the Emerson decision and wrote a memorandum to the United States attorneys saying, yes, in fact, the Second Amendment protects individuals' rights to own guns outside of the context of a militia. He did continue to go, he went on from there to say that, in fact, all currently existing federal gun regulations, including the assault weapons ban, the machine gun laws at issue in Emerson and every other case, every other currently existing law, was constitutional. So this was, again, just John Ashcroft being, I think I'm going to skip the adjective that I was looking for. But suddenly, before most of you were in law school, but after everyone on the panel was in law school, the Second Amendment was very much in play. And that's at the point where I got involved in the issue. The Ninth Circuit rapidly disagreed with the Fifth Circuit in a case called Silvera, and I filed a brief in that case for the Violence Policy Center. Shortly after that, we get to the district, where the issue started getting litigated, and we ended up in front of the Supreme Court today. And I'm not going to walk through the various goings-on in the district's litigation. There were, in fact, two cases, one brought with the sponsorship of the NRA, one brought with the implicit sponsorship of the Cato Institute, though they've never said they were formally sponsoring it. And there were all sorts of issues of standing and such, which in the end I don't think anyone in the audience probably cares about. But the issue before the Supreme Court, which I guess was in fact Paul's question, this was all largely an aside, is the district's gun laws, which, as Paul said, preclude the private ownership of handguns that were not owned before 1975, and preclude the possession of any firearm that is neither disassembled nor protected by a trigger lock, are constitutional under the Second Amendment. So the D.C. Circuit, in a 2-to-1 decision, said that, in fact, the Second Amendment both of these laws are unconstitutional under the Second Amendment. The district petitioned for cert, and the case was argued in March. I think
David, is it fair to think of this case as conservative public interest litigation?
Yeah, I mean, define public interest litigation, I would say. It is certainly the case that nonprofit organizations, the Cato Foundation and the NRA, have been litigating these issues on behalf of individuals on a pro bono basis. So I guess that is probably a fair statement. I wouldn't necessarily want to agree that it was a public interest question, because I'm very much of the view that this is not in the public interest and that we are going down a road that may unfortunately lead to a huge amount of damage to the American public.
Okay. And the people who decided that case are the D.C. Circuit. The United States Supreme Court is going to review its decision. Since I think we've got a bunch of law students in the room, I'm going to ask a classic question of law professors. What's the appropriate standard of review? And I'm going to ask that, to direct that question to Adam.
Well, it's an interesting question. So as all of you law students and practicing lawyers know, with constitutional rights, there's two questions. Is there a constitutional right? And then when can government burden that right? When does the government have sufficiently good reason and does it adopt a policy that's sufficiently well-tailored so that it can survive constitutional scrutiny? Just because you have the right to free speech doesn't mean you have, in the classic example, the right to shout fire in a crowded theater. The government can ban you from doing that, can ban you from committing perjury or fraud through speech. Same thing with the right to bear arms. Just because you have an individual right to bear arms, the question becomes, well, what standard do we apply to adjudicate the constitutionality of legislation that burdens the right to bear arms? And one of the interesting things, David mentioned that Sandy Levinson wrote that article. There were some other people, Don Cates and some other who were very active in the early days of the Second Amendment literature in the early 80s. And what those articles did was not just get the attention of the New York Times, but lead to really a tidal wave in research, largely from conservatives, not exclusively from legal conservatives, but a tidal wave of research into the history and meaning of the Second Amendment right to bear arms. And while there were many, many, many trees felled so that that scholarship could make its case for the original meaning of the Second Amendment, it was, a lot of that scholarship was in a nutshell, was kind of a larger version of what Emerson was in a nutshell. Emerson, that Fifth Circuit case that David mentioned, where they go on for 84 pages talking about the history of the right to bear arms, and then having established that there's an individual right to bear arms, the court then says, well, how do we judge the constitutionality of this law? Well, we're not really sure, but we're going to uphold it, right? Where they use a lot of conflicting language, and the court's very unclear about what standard of review applies. And that's a large part of the scholarship was the same way, is that the scholarship analyzed the historical meaning of the Second Amendment, but didn't spend a lot of attention arguing about what standard of review should the court apply today, assuming an individual right to bear arms. And of course this is an important question, and maybe for a lot of lawyers the reason why they didn't decide to look into the question was sort of an assumption that many lawyers have coming out of being taught by Caroline products and whatnot in modern constitutional law texts, that fundamental rights always trigger strict scrutiny. And what are fundamental rights? Well, clearly the provisions of the Bill of Rights are fundamental rights, and so there was an assumption maybe that strict scrutiny would be the appropriate standard of review. As I've argued in some scholarship that I've done, that's not really a good understanding or an accurate understanding of fundamental rights jurisprudence, and that in fundamental rights area we treat fundamental rights to any number of different standards of review. So the argument's often made, you hear this in the rhetoric these days around Heller, well, the court should treat the Second Amendment in the same way it treats the First Amendment. Well, that's a nice sort of turn of phrase, but it doesn't tell you anything. The First Amendment is subject to so many different standards of review. You get one kind of standard of review for political speech, for content-based restrictions. You get another standard of review if it's content neutral, time, place, or manner. You get another standard of review if the government is limiting speech because it's an employer. You get another standard of review if it's a public elementary school limiting your speech. There are different standards throughout the First Amendment. It's like saying you should treat, the First Amendment is like a rainbow of different standards of review. Saying you should treat something like the First Amendment doesn't answer the question. So I think the standard of review question is a really important one, and the assumption of strict scrutiny really doesn't hold. What I did is I argued in an amicus brief to the Supreme Court that the court should follow the states. There are 42 states with individual right to bear arms provisions in their state constitutions. It's actually 44, but 2 states, oddly enough, read those provisions only to protect a right associated with militia service, and protect against federal interference. Why you'd protect that in the state constitution, I'm not sure. But at least 42 clear, unambiguous statements. And these have been in state constitutions in many states back to the founding era. There's been hundreds of published cases in state Supreme Courts and state courts analyzing the constitutionality of gun control under these state constitutional provisions. What I found in my research is that every single jurisdiction, every state applies the same standard of review. Every state rejects strict scrutiny. Every state rejects intermediate scrutiny. Every state applies what they call a reasonable regulation standard. It's a question that's been asked and answered over and over and over again in the right to bear arms jurisprudence of American constitutional law, but at the state level, not at the federal level. And the basic reasonable regulation standards as well, as long as there are available alternatives, that we will allow legislatures to restrict access to guns, restrict felons from having weapons, restrict where you can have weapons, for instance, in a courthouse or a government building. And the courts say, so long as you're allowing a right to bear arms, that you have access to some weapons to protect yourself and for self-defense, then almost any other regulation, so long as it's not arbitrary and totally unreasonable, will be upheld. It's not quite the same as rational basis review that you learn in your constitutional law classes, but pretty similar in that the ultimate effect is that the court will be relatively deferential to legislatures, and most laws survive scrutiny. It would be interesting to see what the Supreme Court does, what the appropriate standard and what standard they hold is applicable. The Solicitor General got himself in a lot of trouble by suggesting intermediate scrutiny. That led to charges of him being a traitor to the cause of the Second Amendment. So there's a real interesting question. I think most people assume that there will be an individual right to bear arms in the Second Amendment recognized by Heller. I think no one really knows what the court's going to do about the standard of review question, and I think that's where the rubber hits the road.
But Adam, they won't even come up unless they think that there's an individual right, correct? Would you agree with that?
Right.
Okay.
And Professor Tushner, what do you think the appropriate standard of review is?
Well, I'm going to start with a visual aid, but since this is the District of Columbia, it's not going to be a handgun. Yesterday, I was shopping at the grocery store, and I'd been doing a lot of reading of law reviews, and I needed something to relax with. So I went to the aisle where they sell, junk books to read for relaxation. And I found this new book called The Lost Constitution, which is a novel for readers looking for another Da Vinci Code should find this a worthy successor. Apparently, The Lost Constitution actually has a provision that says one way or the other. I just started it. Whether the Second Amendment is an individual right or so just read this book and you'll know the answer. On the standard of review question, I think there's only one tweak I'd give to what Adam said, which is this. You could distinguish. I don't think the court will because it's not the kind of thing that they're likely to do in the first go-round. You could distinguish between the kind of reasonableness standard that state courts apply given that they are dealing with what is clearly an individual right. And so call that a free-floating reasonableness standard. In contrast, at least there are people who argue that the reasonableness standard which should be applied in the Second Amendment context would be reasonableness with respect to a regulation of weapons in connection with membership in a militia. So it's a somewhat different question. A training requirement might be a reasonable regulation with respect to membership in a militia. That is, you want people who have a right to bear arms in connection with their membership in a militia to be able to use them pretty well. You might not want to say that that one could imagine the freestanding reasonableness requirement coming out in the District of Columbia as, gee, there's a huge problem of gun violence in the District of Columbia. And since ownership of long guns with trigger locks is allowed, it's reasonable to ban handgun. Okay. I don't think that's the likely outcome, but a freestanding reasonableness requirement could lead to that outcome. A reasonableness requirement that was geared to militia uses probably would not support that outcome.
We actually had Walter Dellinger here a few minutes ago who argued the case before the Supreme Court. In his absence, we're going to have a rehearing now, and I'll ask Dennis to make the argument that Mr. Dellinger made on behalf of the District of Columbia, and then for a response from Mr. Heller, we'll ask Adam to make that argument. So may it please the Court.
And please don't expect me to do it as well as Walter Dellinger. Before I begin, though, I do want to thank the ACS for inviting me to be part of such an outstanding panel. This is my first ACS panel. I have, however, appeared on a number of occasions before the Federalist Society. My role in those appearances is generally as a punching bag. And it doesn't help me that I keep getting invited back to the Federalist Society, so I guess I'm a pretty easy punching bag. But it's nice to be among friends. I think the most powerful argument I can think of for the traditional militia purpose view of the Second Amendment is the words of the Second Amendment. If the framers sought to guarantee a broad right to have guns for personal purposes unrelated to the militia, like self-defense, recreation, it is very odd that they would choose language that starts talking right from the get-go about a well-regulated militia. And that militia is necessary to the security of a free state. It has to do with security concerns, and they're not security of the home. It's not security of the person. It's security of a free state. And sometimes I wonder whether James Madison, who was the original author of the Second Amendment and the rest of the Bill of Rights, must be looking down on all this and saying, what did I have to do? I put the militia language right in there, and they're still debating this. The right relates to the militia, quite frankly, because the amendment says so. It says it. Now, there seems to be often an assumption that the phrase keep and bear arms is somehow in tension with this militia purpose. In fact, it's entirely consistent with the militia purpose. The term bear arms in that day was a reference to rendering military service. As historian Gary Wills has put it, one does not bear arms against a rabbit. And in fact, the original Madison proposal to the first Congress contained a conscientious objector clause. What an odd thing to put in an amendment that is supposed to guarantee the choice of individuals to have a gun or not to have a gun. And the conscientious objector clause read like this: but no person religiously scrupulous of bearing arms shall be compelled to render military service in person. So it's perfectly clear that whether you can find other instances of the use of the term bear arms in other contexts at the time, it's very clear that in this context, bear arms refers to compelled military service. Well, what about the term keep arms? The Heller plaintiffs thought it was self-evident that keep arms must refer to keeping arms in the home for private purposes. But remember, the phrase is keep and bear arms. It's not keep arms. You don't slice it, you don't dice it. And in fact, the Massachusetts Bill of Rights had this provision: the people have a right to keep and bear arms for the common defense. Keep arms for the common defense. Keep arms in this context. There may be other contexts where keep arms means something different. Keep arms in this context is a reference to the requirement in the militia statutes of the time that every able-bodied male of a certain age acquire a gun for use in militia service. Keep and bear arms means possess guns in connection with service in an organized militia. Now, there were other broader proposals at the time that, had they made it into the Constitution, would have given the Heller plaintiffs a better argument. For example, an amendment proposed by New Hampshire: Congress shall never disarm any citizen unless they have been in actual rebellion. That's a slight paraphrase, a much broader concept, but clearly that didn't make it into the Constitution. And in fact, when you look at the Bill of Rights, the Second Amendment is the only one that has a statement of purpose in the language of the provision. And it is not up to us, and it's not up to the Supreme Court, to ignore that stated purpose. The private rights view, in my judgment, is simply a misunderstanding of history. When I first came to this issue, when I first started reading about it, I kind of assumed that the original intent arguments would all go in favor of the individual rights theory, because obviously guns were very important in colonial times. but so was farm equipment, and so were horses. There were a lot of things that were important. The question is, are guns enshrined in the Constitution in a way that limits the power of our elected representatives to regulate those guns? And there's really nothing in the legislative history of the Second Amendment that suggests that that's what they had in mind. Most of the historical case that is made in favor of the private rights view consists of quotations completely taken out of context in which having a gun is referred to in very positive terms in the Federalist Papers by Patrick Henry, but in fact, if you read the whole passage, they're talking about the arming of the militia. And one of the most interesting things here is that a lot of the history that was developed in those law review articles supporting the individual rights view was history that was uncovered and expostulated by lawyers and law professors. Since then, there has been a massive counterattack against that by historians. Trained historians who know how to read the history, who understand how the language was used. And one of the most interesting briefs in this case is an amicus brief filed by 15 preeminent historians of the period, led by Pulitzer Prize winner Jack Rakoff of Stanford University. I recommend that brief to all of you because it debunks this assumption that history supports the individual rights view. In fact, it's precisely the opposite. History makes it very clear that what they were talking about was the importance of maintaining the viability of these state militias, a system of compulsory military service that existed at the time, which the anti-federalists who were pushing amending the Constitution thought was absolutely essential as a counterweight to the potential tyranny of a federal standing army. The final point I would make is that if the Supreme Court has any respect for precedent, it should endorse the militia rights view. Because in a case called United States versus Miller, the Supreme Court made one of the clearest statements about the meaning of a constitutional provision, I think, is imaginable, in which the court said the obvious purpose of the guarantee of the right to keep and bear arms is to ensure the viability of state militias, and it, quote, must be interpreted and applied with that end in view. One would have thought that that would preclude an argument that it ought to be interpreted and applied with the purpose of self-defense and recreation in mind. And yet, for those who do not respect the precedents of the Supreme Court, apparently that the court was simply clearing its throat when it wrote those words. And I want to make sure everyone understands, before we got here to Heller, this was not a situation in which just the Fifth Circuit in Emerson disagreed with the Ninth Circuit in Silviera. This was a situation in which 9 federal circuits, including the Fourth Circuit, not exactly a liberal court, had endorsed the militia purpose view. And in the case in the District of Columbia that gave rise to Heller, it was the first time that a federal appeals court had ever struck down a gun law on Second Amendment grounds.
Okay, so as Mr. Winkler, Professor Winkler, approaches the podium to argue on behalf of Mr. Heller, we'll recall the conversation we had a moment ago with David about whether this was public interest litigation. And when we think about the appellants in this case, the people who were the original plaintiffs, that's a really interesting question because they were carefully selected. They're not what we might think of as gun nuts. They're people who needed guns for what they thought was public safety. One was a gay man who had been the subject of gay bashing. Another was a woman who'd been had concerns about being attacked in her home. So we think about Thurgood Marshall, the best civil rights lawyer of all time. Professor Tushnet is a scholar of his work, and he knows that he carefully chose the plaintiffs in the Brown litigation. And I think these plaintiffs were carefully chosen as well. So Professor Winkler is not representing somebody who we think of as a kind of traditional card-carrying member of the NRA. So let's hear the argument on behalf of your client.
Well, there's a couple ways you can approach the question of what is sort of the best argument for an individual right to bear arms reading of the Second Amendment. You could sort of address it normatively. What do you think is the best kind of argument that one might make? More descriptively, clearly the best argument for an individual right to bear arms is that the settlers needed them to shoot Indians and grizzlies, because that's the argument that's going to get a fifth vote, Justice Anthony Kennedy. Apparently, the settlers were very concerned, the framers were very concerned that government was going to take the side of the Indians and the Grizzlies against the settlers and disarm the people. Shocking to me, too. So that might be the best argument. But in terms of descriptively, in terms of sort of normatively, I think the historians are actually sort of more dueling on the nature and history and meaning of the Second Amendment. There's certainly a good argument that it was about federalism. That's what most of the Bill of Rights was about restricting the power of the federal government to interfere with the states. But there are a very good number of statements by framers, by founding era generations that would speak to what the original meaning of the Second Amendment was, and that did link it to an idea of the individual and of individual self-protection. There's a good number of these comments. I think that probably my sense of the history is that it's somewhat contested, that the historical original meaning is somewhat contested about the Second Amendment. There's arguments both ways. But maybe the best argument for why an individual right to bear arms might come not from the Second Amendment, but come from the 14th Amendment and the debates over the ratification of the 14th Amendment. The radical Republicans, I think the best evidence for an individual right to bear arms comes from the Reconstruction era, where radical Republicans used the argument that freed slaves were going to be victimized by states and localities, depriving former slaves, the freedmen, of their ability to arm and defend themselves against a hostile local population. And there's quite a number of very powerful statements in the ratification debates and the discussion over the framing of the 14th Amendment that argued that the Second Amendment right to bear arms as an individual for a freedman to defend himself was one of the essential privileges and immunities of citizenship. And certainly for constitutional lawyers who like interpreting the word liberty of the 14th Amendment in a broad way, it's not a great stretch to say that an important or one of the most important forms of liberty is the ability to defend yourself if you're going to be attacked from someone bearing a weapon or bearing an arm, right? If you have to sit there idly while someone attacks you, that's hardly a notion of liberty that we would recognize. So I think the 14th Amendment provides a better argument than the history of the Second Amendment. I also think that there might be a good argument that one could make, and Heller did not make this case, but in analyzing why the right to bear arms might be protected at this point, we might think about it in terms of living or evolutionary constitutionalism. There are, like I say, 42 states, maybe 44, depending on how you cut them, that protect an individual right to bear arms. These provisions have grown in recent years. Numerous states, about a dozen states, have amended their constitution in the last 20 years or 30 years to add individual right to bear arms provisions. You could make, I think, a reasonable argument from a living constitutionalism perspective that we should protect an individual right to bear arms, that the American people are speaking and have spoken on this issue and have decided that an individual right to bear arms should be protected.
That's great, because I was going to ask you to kind of shift your audience for a moment to either the court and Justices Ginsburg and Stevens and Souter, the progressives, or the progressives in this audience, to help us think about whether there's a progressive argument to be made in favor of overturning, I'm sorry, in terms of affirming the D.C. Circuit. You know, when Dennis talked about being among friends now, that kind of contained the assumption that the Federalist Society are all opposed to gun control and we progressives are all in favor of it. But is that necessarily so, Adam?
I don't think so. And actually, I think one of the most interesting things about my experience in the Second Amendment literature is when I go and I talk to the people at the Institute for Justice who've been very active on the Heller case, on Heller's side, on the right to bear arms side. When we sit down and talk and I say, okay, so assume the court strikes down this D.C. law. The D.C. handgun ban is an extreme law. There's only 2 municipalities in the country that have laws as extreme as that. As constitutional historians often argue, the Supreme Court's especially likely to stamp out outliers, then that might lead one to believe that the D.C. law is likely to be invalidated because, in part, it is an outlier. But one of the things that I think unites most mainstream people on both right or left is that there is some place for reasonable gun control. I don't see many people arguing, at least mainstream legal thinkers on either side of the aisle, arguing that bans on felons having weapons should be invalidated, or that machine gun bans should be invalidated, or that people should be able to have arms, including hand grenades or bazookas. Right? There are certainly differences in debates as to what gun control is appropriate, concealed carry laws being a good example. But I think actually that there's a lot of space for progressives and conservatives to agree that, well, maybe there's an individual right to bear arms, but that's not necessarily inconsistent with basic reasonable gun control that enhances public safety and that makes sure those who use weapons do so in a relatively careful way. So I think it's possible.
Great. And one quick thing, you made a reference to grizzlies and Indians, which is something that came up in the oral argument in this case, just so everybody knows what you meant. Can you?
Well, yeah, so in the argument, so one of the big questions for everyone was, none of the justices really, I think with the exception of Justice Thomas and maybe Justice Scalia, had ever really said anything about the Second Amendment, whether it protects an individual right to bear arms. So there was a lot of people were saying, well, what are the courts going to do? And I think a lot of people were assuming, well, there's a number of Chief Justice Roberts, Justice Alito, relatively conservative. Their Federalist Society credentials are well established. They're likely to think that there's an individual right to bear arms, but no one really had any sense. But even if you did, you put those in the conservative camp, individual right to bear arms camp. Maybe you think Ginsburg, Stevens, Souter, and Breyer, they hadn't said anything, but somewhat moderate. Maybe they were going to be in the collective rights or individual right associated with the militia only camp. And again, people were paying attention. What's Kennedy going to do? Right? Kennedy, the swing justice, and as Dahlia talked about in the lunch program, it only took about 2 minutes into the oral argument before he revealed his cards, and he said that, well, clearly the framers were trying to protect have an individual right to bear arms to protect the settlers from being disarmed, so that they could battle the grizzlies and wolves out on the range. So that's what I was referring to there. So it's an argument that I don't think I had ever come across in my review of the literature of the Second Amendment. I mean, and there's some crazy ideas out there in the Second Amendment. The insurrectionist theory of the Second Amendment, that you need to protect the right to bear arms so people can revolt against the government. I think that's a dangerous idea if I've ever heard of one. But this is one crazy idea that had never been given voice to before, but I imagine there's going to be a great article about the grizzly bear protection of the Second Amendment within the next year.
And Justice Kennedy, who would have thought, again, he hadn't opined about this issue. No one was quite sure where he would come out. Before the court accepted cert, Professor Tushnet was asked how he thought, if the court accepted cert, the case would come out. And he said, my gut feeling is that there are not 5 votes to say that the individual rights position is correct. Justice Kennedy, Professor Tushnet said, comes from a segment of the Republican Party that is not rabidly pro-gun rights. And indeed probably is sympathetic to hunters, but not terribly sympathetic to handgun owners. Then the standard liberals will probably say collective rights. Professor, do you still think that?
No. I guess there are a couple of things I want to say. One, actually, is on the bazooka question or the anti-tank weapon question, there's actually some support in the pro-gun rights position for the proposition that people have a right to own bazookas. Nelson Lund is unsure about that. Nelson Lund is the George Mason professor of the Second Amendment at George Mason University. He's unsure. He's uncommitted on the question. The second thing is, it's interesting that, I find it interesting, we'll probably talk a little more about this, that people on the pro-gun rights people and the pro-gun control people both think that the text clearly resolves the question in their favor. Dennis described the pro-gun control people, says militia. I wrote the book and sent it to my sister. My sister's a standard liberal. Book is in the middle on the question. I talked to her. She said, it says militia. What do you mean? The gun rights people say, it says the right of the people. It's a right, just like all the other rights. Now, Adam has this fancy argument that just like all the other rights doesn't mean exactly what they think it means, which may be correct. But what is striking is that in the sort of public discourse about this, the text is what everybody thinks on both sides resolves the question. My own view, this is sort of an odd way of putting it, and I don't want to be pushed on the metaphor too strongly, is that if you look at sort of the original understanding and the political theory animating the founding generation, it's sort of 60-40 in favor of the individual rights point of view, On the other hand, if you treat the question as what I would say an ordinary question of constitutional law, where you take into account a whole bunch of other stuff, including precedent, including a course of regulation and the like, then it's sort of 70-30 against the individual right position. Now, that's not a prediction of what the court's going to do, and a lot may turn on the relative weight people give to original understandings and founding era theory. Even if you give it a lot of weight, it's still, I think, a closer question than people on either side think it is. But, it's hard. I'm not even going to say if I were to cast a vote, because who cares what
we all care, Professor. How would you vote?
No, I was very careful in the book not to take a side on this. I actually don't have any dog in the fight. I was interested in figuring out what was going on, and when you try to figure out what's going on, it's a mess, I think. And so whichever way they come out will be legally defensible.
And whichever way they come out, after the oral argument, the widespread assumption is that the court will affirm the D.C. Circuit based in part on Justice Kennedy's seemingly kind of broadcasting or forecasting his vote. You don't know, but in terms of the conventional wisdom, just show of hands by the panelists, do you think the conventional wisdom is correct that the Supreme Court will affirm the D.C. Circuit? Do you all agree? Everyone agrees with that.
I don't actually necessarily agree with that at all. I mean, I think there are two questions in there, and I think we have to carefully differentiate the question whether the court is going to accept the so-called individual right, meaning the right to possess arms for personal uses, from the question whether they're going to affirm the D.C. Circuit, because, and this goes back to where Adam started with talking to, which was once one accepts the fact that the Second Amendment precludes the federal government from regulating, from barring, or from once one accepts the proposition that the Second Amendment imposes restrictions on the federal government's ability to regulate the possession of arms, one then has to ask how reasonable are these specific regulations, and are these specific regulations defensible? And then there's a second question of whether that has any effect whatsoever on state or municipal regulations of guns outside of the District of Columbia. And I want to get back to that. But anyway, so I would differentiate. So I will agree with where you were going with the question that it is extremely likely that at least 6 justices will accept the so-called individual rights view. I just don't agree that they're going to affirm the D.C. Circuit.
And if that happens, what would the world look like? Which kind of brings up the issue that you raised, David. And Adam, I know you've been a student of state constitutional law on this issue. Lots of states recognize an individual right as opposed to a collective right. The sky hasn't fallen in those states, and we could have a good argument about gun violence in those states, whether it's any better or any worse. But what's likely to happen if the court finds in favor of an individual right based on the state experience?
Probably not very much. I think it would be an interesting empirical study that I've thought of doing is to assess and evaluate the gun control provisions in states that do have individual right to bear arms provisions and contrast them to those existing in states like California that don't have constitutional provisions for an individual right to bear arms. bet that overall, statistically, you wouldn't find a huge variation between those two sets, while within the sets you might have some variation. That I actually think that what the state constitutional law tells us is that you can have an individual right to bear arms and have reasonable gun control and have gun control laws. And I think that no matter what the court says about the Second Amendment, unless it really gets outrageous, we're going to have plenty of gun control law in this country after this Heller decision, even if the court says an individual right to bear arms. Because most of the gun control in America, not all of it, and we could all disagree on the particulars, most of it's pretty reasonable. The gun lobby and gun owners are a very powerful political force, and they don't let legislatures enact with much frequency extreme, excessive burdens on the right to bear arms. So things like that bans on felon from possessing firearms, things that laws that ban minors from having access to firearms, or people who've been institutionalized and determined not to be mentally fit, or laws that ban guns where alcohol is served or in government buildings. Those laws are still going to be there, I think. I think there's, no one knows what the future brings. There'll be interesting political debates. This will affect and shape political debate and how it works, and that might lead to some laws being invalidated. If this law is invalidated in D.C., the handgun ban, it's likely the next law to go down is Chicago's has the same kind of law banning handguns. That's going to go down pretty quickly.
Let me flag that I disagree with that.
Yeah. What?
Let me flag that I disagree with that, having filed a brief for the city of Chicago in Heller.
Well, at least it might go down. It would be a reasonable prediction. And then, according to the people on the Institute for Justice who've been backing this litigation, they say probably the only other thing to go might be some discretionary permitting laws. So some states allow you to get a permit you have to get a permit to get the right to carry a weapon, but there's some discretion that the administrative official has in terms of who gets it and who doesn't. That those laws may go down. But if that's it, that's not going to be a huge impact on America. That's not to say you couldn't have an outcome that has a huge impact on America or gun control. I just don't see that as a very likely outcome in light of the state experience.
Okay, real quick, David.
Sure. For starters, I think most of the sociological and sort of political science research that I've seen, and Dennis knows more about this than I do, I'm sure, suggests that, in fact, the only gun laws that actually do any good are gun bans. So most other regulations actually don't do much to actually affect violence levels and such. And so I think even if one allows for a system where there's reasonable regulation is quite likely going to include handgun bans. Handguns in particular are by far the most common weapon used in crime violence. They're the most common weapon used in crimes of passion. They're the most common weapon that is accidentally used by children and in ways that harm children. So I think that there are extremely good arguments that handgun bans, such as the districts and such as the city of Chicago's, can survive even in a reasonable regulation regime.
So
Second point.
It would be reasonable to prevent people from using guns for self-defense?
No, because for self-defense, self-defense in most situations, a shotgun or other sort of firearm can be equally good. For defending your house, a shotgun, frankly, is better than a handgun. The only possible situation in which a handgun is a better weapon for self-defense might be street violence. But that said, there's so much evidence showing that if someone has a gun on them in a situation where there is street violence, it increases the chance that they themselves are in fact going to get killed. Just having a gun in these sorts of situations is the biggest predictor of violent death.
Okay, I'm a little concerned, David, that your argument proves too much, because it sounds like you're going towards it would be reasonable to have, or most reasonable, to have a total ban on guns. That would be the best for society, so that's the most reasonable, even though that's inconsistent with what we expect the court may find. Dennis, what about the D.C. law? Let's say that there's an individual, the court does make this conclusion that it's an individual right. The D.C. law is the most extreme. Surely that goes too far. I'm wondering if the Brady organization has ever seen a handgun law that it didn't like, a gun control law, that is, that it didn't like?
Well, actually, yeah, just to clarify that, the Brady organization does not support a handgun ban, and I strongly disagree with the statement that was made earlier that the only effective gun control is a handgun ban. Actually, there's a whole range of life-saving gun laws that we have on the books. There's a range of life-saving gun laws that we need to enact that fall far short of a handgun ban. For example, the Brady Bill has made an enormous impact. The Brady Bill has stopped 1.5 million high-risk, dangerous gun purchasers, including felons and people who are dangerously mentally ill, from buying guns since it was enacted. And since the Brady Law was enacted, we have had a spectacular drop in the use of guns in crime and a spectacular drop in homicides. That doesn't mean we should stop at the Brady Law. We should extend those Brady background checks to all transactions at gun shows, to all private transactions, and the idea that that would not save lives, that the only measure that could possibly save lives is a handgun ban, is just not true. So what's really at stake here is whether what comes out of the Heller decision is going to constitute a constitutional threat to common sense laws that help us keep guns out of the hands of kids and felons. It's not enough simply to say that felons can't buy guns. It wasn't enough before the Brady Law because we didn't have a background check to tell whether someone was a felon. You need these controls on access in order to have an impact. One of the most interesting comments I heard during the oral argument on March 18th was by Chief Justice Roberts, when he said, well, is it such a good idea to start our Second Amendment jurisprudence by stipulating an all-encompassing standard that would apply to all cases? I thought that was very interesting because it suggests to me that Roberts may be driving the court towards basically a case-by-case determination here. And the D.C. gun laws, the laws at issue in this particular case, are the strongest in the country. They are not the kind of laws that we as an organization advocate for the nation. There's not only a handgun ban, but there's also these peculiar restrictions on long guns in the home, shotguns and rifles, where the wording allowed the Heller plaintiffs to make an argument, which I think some of the justices were hearing, that the way that those provisions are worded, you can't even unlock your shotgun when the criminal is coming through the sliding glass door. Now, I don't know, there are lots of safe storage laws on the books at the state and local level. They require you, when you're not using your gun, to keep the gun locked and unloaded and away from kids. Those laws have saved lives. A perfect example of the kind of law that saves lives but doesn't ban guns that we need to preserve. But that's not the way this law is written, and it's quite conceivable that the court could say, look, in this case, this peculiar package of laws is such a burden on the use of guns in the home for self-defense that it can't withstand Second Amendment scrutiny. But there may be a range of other laws that actually save lives by restricting guns and making them less accessible to dangerous people and yet allow the use of guns in the home for self-defense. And if that happens, obviously we would be very pleased because that is our agenda. Our agenda isn't a handgun ban to begin with. So I think, following the experience of the state courts that Adam Winkler has so well documented, that's also encouraging because those are broadly worded right to bear arms provisions, and the courts have shown a great reluctance to interfere with the judgments of elected representatives on these life and death policy issues. The problem is, as we all know, there are a lot of right-wing activist judges who populate the federal judiciary. There are a lot of Judge Silberman's out there. He wrote the Parker decision that is up on for review to the Supreme Court. It makes us very nervous. But I'm hoping that when the dust settles, if they endorse an individual rights view, if they strike down the D.C. law, I'm hoping that 10 years from now we will be able to look back and say, well, it was more of a symbolic victory for the pro-gun people and has not interfered with the enactment of common sense gun laws.
Okay, a couple of other quick questions, and then I want to open it up for your questions and comments. Professor Tushnet, we've been thinking about if the court finds an individual right, the effect that would have on law. How about the effect on policy public policy, and also, a different question, the way that we talk about public policy.
Yeah, I think one of the, possible outcomes of a decision striking down the D.C. gun ban on the ground that it is, as Chief Justice Roberts kept saying, a complete ban, might be to make it easier to enact what Dennis is calling common sense gun regulations, because an important component in the argument against background checks or the gun show regulations has been, an important argument against those regulations on the part of the gun rights people has been that this, if we allow this, it's just the first step towards confiscation. Well, if confiscation is off the table as a result of the Heller decision, that argument at least becomes much more difficult to make. And so it might be politically more significant for gun control people to, in some sense, lose this case than to win it. The second thing is on how we talk about guns. This is the most striking thing I found when I was working on my book, is that this is really a cultural issue. We talk about culture wars, red states versus blue states, and stuff like that. The position you take on what kind of gun regulation is desirable, constitutionally permissible, is not a freestanding position. That is, it's connected to your views about a whole bunch of other things, like how risky is the society? How safe is the society? Are we all responsible for each other, or are each of us responsible for ourselves? Now, and defending ourselves. Now, whatever the court does about that, those cultural issues are not going to go away. The only thing that might happen is that the sort of political heat under the issue of gun control itself might be turned down some, so that the cultural wars can happen, but on some other issues. My own view is that that's sort of the best outcome we can hope for.
It's the best outcome, but if you are a true believer in gun control, is it the best outcome? Professor Tushner has written, any gun-related policy likely to survive a political process deeply affected by the culture wars won't do much to reduce violence. And Professor, you use as your example background checks at gun shows. You say, you can get those through the political process, but they don't make much of a difference. David, is Professor Tushner right?
I don't think so. And this ties into something I wanted to say about the last question to me. Gun laws, the vast majority of gun laws in the United States today are state, or even more to the point, municipal gun laws. So, for example, the city of Chicago has a handgun ban. That was enacted by the city of Chicago city council, and has been, various people have tried to get the city council to repeal it. They failed. So that is a local gun control ordinance that went through the political process and that was fully vetted in that process. And frankly, if someone in the city of Chicago, someone in the Chicago metropolitan area wants to own a handgun, they can move to Oak Lawn and own a handgun out there. And that's the way the political system has historically worked. And I think regardless what the court does here, that level of differentiation between more strict gun laws some places and less strict gun laws elsewhere could and should survive, which ties into the legal argument I wanted to make before, which is the only legal question before the court in Heller is about federal restriction of guns. the District of Columbia is sui generis as a federal entity, but what all the court can say here is whether the federal government, either in the district or nationwide, can restrict guns. And whatever they say here should really not impact the incorporation debate and the question whether the state of California can enact gun laws and whether those gun laws are constitutional, because the court has held since the mid-19th century that the Second Amendment isn't incorporated against the states, and there are deep historical reasons why that is and should remain true. I mean, of course, those cases predate the court's selective incorporation jurisprudence, but regardless what one thinks about the individual versus militia-based rights debate, it's quite clear that much of the debate on the Second Amendment had to do with the power of the states vis-a-vis the federal government as to guns. And so even if the Second Amendment precludes federal regulation, I think the city of Chicago's gun laws and other locally enacted laws that are likely to survive a political process, to use Mark's terms, should still be constitutional.
Okay, so my last question has to do with the panel that a lot of us just went to about constitutional interpretation and originalism. So I want to ask both Adam and Mark what we can learn from the Heller litigation about constitutional interpretation generally, and especially about originalism. But first, Dennis, to kind of lead us down that road, another quote from Professor Tushnet. He has said that gun control proponents have good arguments. You guys do have some good arguments on your side. But outrage at claims for a right to resist an oppressive government with arms isn't one of them. So he thinks whether you guys like it or not, the Second Amendment does have something to do with the right to resist an oppressive government. What do you think?
I have to confess I'm one of those who has shown years of outrage about this argument. I happen to agree with Professor Winkler. I believe this is a very dangerous doctrine, actually. I have called it the Timothy McVeigh theory of the Second Amendment, that the whole point of the amendment is to have arms should the government cross the line into tyranny. And Timothy McVeigh was a believer in this doctrine. People actually overlook the degree to which his motivations were dictated by the gun issue. He thought that the federal government was going to confiscate everybody's gun, and he targeted that building because ATF, the Bureau of Alcohol, Tobacco, Firearms, and Explosives, was in that building. Now, that said, just as a constitutional matter, I think it's an extremely odd claim that this is all about the right of insurrection against the government, because I guess I take heart in the words of Justice Jackson. The Constitution is not a suicide pact. You cannot find within a Constitution the seeds of its own destruction, and you certainly can't find within this Constitution the right of insurrection or the right to be armed to prepare for insurrection. In fact, the Second Amendment references the well-regulated militia. As you pointed out, there are militia clauses in the constitutional text that define the power of the state versus the federal government over the militia, that actually give Congress the power to call out the militia to suppress insurrections. So it would seem very odd if this reference to the militia in the Second Amendment is translated into a right to engage in insurrection when the whole point of the militia was to suppress insurrection. So I think the insurrectionist view of the Second Amendment is something I've written quite a bit about. I think it's wrong. Whatever right to insurrection there is maybe some kind of natural right, but it certainly can't be a constitutional right. And if it is a constitutional right, it would be very unfortunate if it limited the power of government to stop the stockpiling of weapons by, for example, right-wing paramilitary groups, the Ku Klux Klan, which actually did invoke this insurrectionist theory to try to get constitutional protection for its paramilitary wing in a case decided in Texas back in the 80s. This would be a charter for insurrection that would, I think, threaten the very Constitution that we all love.
Okay. Adam. constitutional interpretation? What can we learn from Heller?
Well, I guess that remains to be seen by what Heller says. So we don't know how they've interpreted the Constitution, and the lessons will be found probably in the example. But certainly one of the things that we can take from the process of Heller, from the oral argument, from the briefing, there were, I think, about 80 amicus briefs filed in this case, an enormous number of amicus briefs. I can't claim to have read them all, but read a pretty good number of them. One of the more remarkable things is here you have a question of constitutional interpretation that is unusual in that it's not burdened by too many precedents. There is the Miller case, but it's an old case, and it has some ambiguities to it. So there's not much precedent. There's not much statements out there. There's not much case law at the Supreme Court level on this. So how did people go about interpreting the Second Amendment? Well, if you looked at these 80 briefs, the one thing as a constitutional law professor who makes a good point every year to tell my students about different theories of constitutional interpretation and cover Ely's process theory and living constitutionalism, passive virtues, and all these various things, is that these briefs were about 98, 99% originalist. Right? Originalism has governed the day, certainly in the main briefs of both parties here, both the District of Columbia, a brief that Alan Morrison, who's here, worked on, if not wrote most of, as well as the Heller brief. The debate is about the original meaning, and I think part of that speaks to the triumph of originalism as a theory of constitutional interpretation, that no one is going into the court. An academic might make an argument about, well, a living constitutionalism approach supports the right to bear arms here, but no one goes to the Supreme Court to make that argument. In the Supreme Court, you're going to make your argument from original meaning. You might bring some pragmatic considerations in that invoke living constitutionalism concerns, but the arguments here are very self-consciously about the original intent or original meaning of the Second Amendment and the 14th Amendment, how it might change. So I think it really shows that for those who are big believers in evolutionary constitutionalism, how far there still is to go before that is considered a really acceptable way to go to a Supreme Court and say this is how you should interpret the Constitution. Okay. It may be a great description of how the court has interpreted the Constitution, but it is not the normative argument you make to the court when arguing it should interpret the Constitution in such a way.
How about that, Mark? Last question for you. So when you forecast Justice Kennedy's vote, it sounded like you were thinking a lot about politics. He's part of this kind of liberal, not so upset about gun control wing of the Republican Party, so that's what he's going to use. But in his questions at oral argument, it sounds like he is thinking a lot about originalism.
Yeah, well, I think the lesson I would take from it is actually not about originalism. It's about, constitutional interpretation. This is sort of the crude and overbroad version. Constitutional interpretation, in constitutional interpretation, it really helps if over an extended period you've had an interest group or a social movement propounding a view of the Constitution, and that social movement or interest group is an important component of a political coalition that has managed to sustain itself over a long period, because those are the folks who are going to be on the courts that are going to be deciding your case. That's the lesson, I think. Not about originalism. Originalism happens to be the hook that the gun rights people have worried about. On the other hand, nobody in the relevant universe thinks that the original understanding had anything to say about the unconstitutionality of punitive damages. But lo and behold, here's the Supreme Court saying there are constitutional limits on punitive damages. That's not because they're originalists in any important sense. It's because, to put it crudely, they're Republicans.
What do you think? Comments? Questions? Yes? Yes.
One thing wasn't mentioned in the language is you use the word well-regulated, which appears in the Second and no other amendments. It's an odd idea to think that there's a right, but the right is something that's well-regulated. Well-regulated free speech wouldn't make much sense. Do you think that language has any play? Why is that not mentioned in debates? Why is that not language?
I think it does have, it should have play. I don't know whether it will for the majority of the Supreme Court. It actually says well-regulated militia. It doesn't say the right is well-regulated. But that's very important because a lot of the sort of individual rights law review treatment of this has completely distorted the nature of the militia as it existed, as if the militia were just kind of an unorganized collection of people. Some of them have guns, some of them don't have guns. That was not the well-regulated militia. As I think I mentioned, the militia was a system of compulsory military service imposed on the adult male population.
White male.
And white male population, exactly. And it was, people were armed by government mandate to be militiamen. They didn't simply choose to own a gun to be a militiaman. In fact, the year after the Second Amendment was ratified, Congress enacted the Militia Act of 1792, which created all kinds of regulations requiring people to, these militiamen, to acquire their arms within X number of days of enrolling in the militia. So it was an organized military force. It wasn't simply an ad hoc collection of citizens. It wasn't a private militia of the kind that got notoriety a number of years ago, the Michigan militia, forming themselves into a private army, the paramilitary activities of the Ku Klux Klan. That wasn't the well-regulated militia. And it's well-regulated militia being necessary to the security of a free state. It was inherently an institution of the government. And the point of the Second Amendment was to guarantee the right of the people to be armed in an organized state militia, and that right not being dependent upon the federal government. So if the federal government was hostile to the militia, if it did not arm the militia, as it had the power to do, if it ignored the militia, then the people have the right to be in an armed state militia. That was a right granted to the people by the Second Amendment. And that's the whole point of it. It had nothing to do with personal self-defense.
Dennis, do you detract a little from your cause when you're that certain? I mean,
well,
it's been a huge issue, right, for a number.
Well, you know, it's not. I'm not the only one who is that certain. If you read, I mean, there are whole books written by some of these historians who signed this amicus brief, and they're just as certain as I was. It's not that people didn't believe in the right of self-defense. They did. They saw it as a common law right that was brought across the Atlantic from Great Britain. But they never sought to build into the Constitution a right to own particular instrumentalities of self-defense beyond the regulation of the government. This is not about the right of self-defense. Okay. This is about the right to bear arms.
A question over. Actually, only a few minutes, a bunch of questions. So why don't we have each of you ask your questions, and then we'll have the panels respond. So you first, sir.
Okay. Back to the question of originalism, and I guess it's for any of the law professors or anybody up there, but when else have progressives advocated for such an originalist reading of the Constitution on an issue that you know, fundamentally deals with, I don't know if you want to call it a civil right, I guess that's maybe a stretch, but with the expansion or restriction of a right? It seems to me that were you to try to apply such an originalist reading to the First, Fifth, 14th Amendments, any of the other ones that tend to be near and dear to progressives' hearts, that would seem to gut much of the progressives' view of the world, or special issues. And so I guess the question is, what makes the Second Amendment different?
Okay. And sir, if you could ask your question, and then we'll have the panelists respond to both.
Well, it actually dovetails with that one, I think. My question was very similar, and it's also this issue. I've been confused, I guess, as a progressive and a member of ACS, at the reaction to this question that I think the so-called liberal legal academics have utilized as they approached it. Because I guess my question to you is almost on the meta theory of what's going on and why people are reacting the way they are. Because as I see the progressive cause and trying to find a consistent approach to constitutional interpretation, it's always been to sort of err on the side of an individual right and to limit the interference of the government. And I'm particularly troubled, I think, when I hear Mr. Gossett's comments about the city of Chicago and the idea that if you don't like it, you can move and you can seek the right elsewhere. And that kind of NIMBY approach to what might be a constitutional right is a little troubling. And in the past, in the issues like abortion or affirmative action or anything else, I think progressives have always taken the cause of the people who would act on the right, the people that are actually sort of embracing what it is they feel the government is interfering with. And I don't know how many diehard gun owners there are in this room as we're discussing this issue. And so I guess that's my question, is just why do progressives who otherwise really protect, go for the individual rights interpretation, why have they utilize this entirely different paradigm to approach this issue?
Well, let me just make one comment on it, and then I'm sure there will be many others. For me, each of the amendments has its own language, its own history, and I just think if you respect the text, you have to understand that the Second Amendment is fundamentally different. It's the only amendment that has a statement of purpose. It's the only amendment that makes the security of the state the ultimate objective of the guarantee of the right. It's got to be regarded as fundamentally different. And so I know that, civil libertarians have been troubled by this. They think they're being inconsistent by supporting gun control, supporting a narrow reading of the Second Amendment. I don't think there's any inconsistency, because I don't believe that the language or the history of this particular amendment reflects a provision that was designed to restrain the power of our elected officials to make these policy issues about the availability of guns in the same way that other amendments restrain our elected officials from infringing, for example, the right to talk about guns. The right to talk about guns is very different than the right to manufacture them, sell them, or own them. And I don't think it was anywhere near the framers' intent to interfere with the power of elected legislatures to do the latter.
Great. David, do you have a quick response, or do you want to take one more question?
I more or less agree. The only thing I'd add is that I'm all in favor of a reinterpretation of the Privileges and Immunities Clause. I think we should be trying to overrule the slaughterhouse cases.
Just a quick comment, but also I don't think it's an accurate description of progressives and their view towards rights. All right, so one thing that defines progressivism in the post-New Deal era, right, is that economic rights of property, rights of contract, should be subject to government regulation when necessary in the public interest. So I think progressives have not just taken a uniform view of expansive individual rights provisions. I think that there's expansive in some ways and narrow in other ways. So I just don't necessarily agree that progressives are always about expanding individual rights. I don't think that's quite right.
Last question. Yes, ma'am.
I have a sort of a practical question. If you were Justice Kennedy and you're convinced, apparently, that this is an individual right, subject, however, to reasonable regulation, but you don't want to leave that reasonable regulation wide open for fear that it might lead to disastrous consequences, how do you give content to what the meaning of reasonable regulation is? What rule do you use to define that?
Well, I mean, I think the best thing the court should do is just look at the state law, right? So this is a very well dealt with question in state constitutional law. And what it basically comes down to is it has to be a reasonable regulation of the right. What that means is you can't eliminate the right? You can't, Paul suggested earlier, well, maybe you could just get rid of all handguns and that would be reasonable for society. That might be reasonable for society. That's a rational basis kind of approach.
Adam, what have state courts struck down? Because, I mean, I know there have been state challenges to the Chicago handgun ban under the Illinois Constitution, which protects an individual right, and it was still upheld as a reasonable regulation.
So what the courts say is that the provision must destroy, eliminate, or nullify the right to bear arms in order to violate the reasonable regulation. A ban on a particular type of weapon have been upheld in every state court to adjudicate it. Usually it's machine guns or assault weapons or sawed-off shotguns. There is one handgun case where they upheld a handgun ban. So bans on particular weapons are allowed so long as there are available alternatives for you to defend yourself. So that you have to protect some right of access to firearms for self-defense. That's what the state courts have said. And so they've crafted reasonableness sort of shorthand for deference, so long as, we'll stop states from imposing arbitrary restrictions or restrictions that effectively eliminate the right to bear arms.
And Mark, since you wrote the book one of the books that's helped define this today, we'll let you have the last word. And just, the interesting thing about your analysis is the Supreme Court hasn't heard one of these cases for, 70 years. Most people think it's going to decide the case. interpreted the law in a way that's different from what people have expected, is going to have some effect on gun laws. But you say, well, in the real world, it's not really going to make a difference. What's that mean about law?
Yeah, well, I think that's an important question, and it says that, law is what we do. It doesn't mean that that's the most important thing in the society. There are many things that have... one of the things about the gun control issue, gun rights versus gun control issue, is that it's... I want to assert this in a strong way that I know Dennis will disagree with. There are... I think we know that there are many better ways of reducing the levels of violence, crime, violence, and gun violence in society than expending effort on getting gun regulations adopted. Apparently, this is not something that I really studied a lot, but apparently the 100,000 Cops Initiative was more effective in reducing crime, violence, and gun violence than anything else that's come down the pike. If you're doing crime and violence policy, that's the kind of thing that you ought to focus on, and guns are, I think, a secondary issue.
Well, what I knew for sure was that this was going to be a learned and provocative panel, and indeed it has been. Thank you, gentlemen.